Should I redo my estate planning documents after my spouse achieves Medicaid eligibility? Our answer here at Heritage is absolutely. When I have a married couple and one is applying for medical assistance, oftentimes some accounts are owned jointly, the house is owned jointly, but when we apply for medical assistance, the house can be owned by both. It can be owned by mom or it can be owned by dad. See, ownership controls what happens to your stuff when one of you passes away. And if the healthy spouse passes away first, now oftentimes we don't expect that, but it does happen. And if you own a house jointly and the healthy spouse passes away first, that house is jointly held by mom and dad. So when one joint owner passes away, the applicant that's still in the nursing home now owns the entire house. And when the person in the nursing facility passes away thereafter, that house is oftentimes lost to estate recovery. But there are no transfer penalties between husband and wife. So when we're applying for medical assistance, mom can own it or dad can own it. So oftentimes what we do is we take that house and we put it into the name of the healthy spouse. Therefore, individually owned assets would be controlled by the will. And if I have a healthy spouse that unexpectedly passes away first, that individually owned asset will then be controlled by their last will and testament. That's what your last will and testament controls. And oftentimes that new last will and testament says everything to my kids instead of everything to my spouse. Because if you don't change the documents and that healthy spouse passes away first, everything will then revert right back through the last will and testament to the applicant that's in the nursing home, therefore losing everything. So absolutely, we redo estate planning documents immediately once we get Medicaid eligibility for one spouse in a married couple.